court should try and make that determination, and other processes can follow. As I close my presentation, because I have 1 minute, I would also like the court to consider very carefully whether we indeed have the threshold to declare a candidate as having won this election. As we speak now, we cannot determine whether we are not sure about the total valid votes that were cast in this election. And without that, you cannot determine whether we have a 50+1 threshold. And I ask the court to look very carefully. In my opinion, we do not have that. There's a lack of clarity. Mahat's presented figures, which I would say many of them were based on presumptions and projections. And that's not what the IEBC should be doing, not giving us projections. That is for the analysts to do. Independent analysts can give us projections, but for the IEBC, they must give us specific figures. They cannot give us figures that are merely projections or made up based on presumption. The figures of how many voters were astray, how many ballots were astray, should be verifiable. I urge you, my ladies, and when you sit to deliberate, let's make things right for our country.
Madam Chief Justice, kindly permit me to seek your guidance. I also appear in the same matter. There were some two specific questions that were put to me by Justice Lenaura and Lady Justice Jokindongo. I will only take 3 minutes and attempt to answer them. Madam Chief Justice, the question was put to me to try and link my arguments with the issue that we are canvassing here in respect to the number of the constituencies that must participate in a presidential election. To attempt to answer that question, Madam Chief Justice, permit me to refer the court to Article 136 of the Constitution, which provides that the president shall be elected by registered voters in a national election conducted in accordance with this Constitution and any other act. That election, the directive of how that election is to be conducted, my lady, is found under Article 138, Clause 2, which provides that if 2 or more candidates for presidents are nominated, an election shall be held in each and every constituency. And therefore the question is, the use of the word or deliberate use of the word constituency is deliberately used by the Constitution, and these constituencies are determinable. And if you want to determine these constituencies, you therefore go to Article 89 of the Constitution. You also further go to Section 2 of the Election Act and see what defines this particular constituency. Why is it important for us to factor this in? It's because any voting that was done outside the Republic of Kenya that is not contemplated by Article 5, which defines the territory of Kenya, then any vote that was cast is an illegal vote, is an invalid vote, and it is a vote that goes towards contaminating the election. Further, my ladies, my lords, in answering the same question, the constituency that was defined by the chairman makes us to have 291 constituencies, completely out of the realm of the Constitution. And that is the illegal infractions we are saying that the election has been infiltrated with. My ladies, my lords, when you are applying these arguments, or considering my argument, consider that you held in Raila 2 that under Section 83 of the Constitution, if any of the issue, either be it legal or factual, is proved and ascertained, then that issue can void an election. The question of the constitutionality of that one extra constituency is an issue that contaminated this election, and it's an issue that should be factored and should not be lost in the eyes of this court. Finally, allow me to sum up by saying that Thomas Paine quoted and said, "A body of men holding themselves unaccountable to nobody ought not to be trusted by anyone." If IEBC does not hold itself accountable to anyone, then who should trust them? Can we even trust the processes under which they have taken through this country? I bet not. I beg to rest. Much obliged.
Next is counsel for the sixth petitioner, Okio Mtata and others. 15 minutes.
May it please you, Madam Chief Justice, Madam Deputy Chief Justice, and members, honorable members of the Supreme Court, I wish to respond in 15 minutes, which I shall share with Mr. Okio Mtata to break down the figures to show that the threshold under sub-article 4 of 138 was not satisfied because the numbers simply don't add up. But I will make a few remarks, Your Ladyship, because there are a few questions that I needed to respond to as well. It is now clear that the ipse dixit of the petitioners on the question of compliance and non-compliance of the Constitution is now sound. And clearly Articles 81 and 86 are in question on compliance. The respondents, my lords, have put up, the second respondents have put up a self-righteous and pompous response on the question of the role of the chairman. And I want to just respond in this manner, my lords. Section 5 of the IBC Act defines what a commission is. And a commission is defined to include the chairman of the IBC and the members. That definition, my lords, contrary to the submissions by Mr. Karori, senior counsel, does not include and expressly excludes the staff of the commission. It cannot therefore lie in the mouth of counsel to submit that the verification and the tallying of the results of the presidential elections, insofar as Form 34As and 34Bs were concerned, was done by the staff and excluded the commission, who are confined to other duties. My lord, that was a violation and an infraction that expressly went against the requirements of Article 138, 3C. Secondly, my lords, the submissions by learned friend, senior counsel, Professor Githu Muigai, on the executive status of the chairman of the IBC, I think should be taken with a pinch of salt, because Article 249(1) of the Constitution does not contemplate an imperial chairman who is all-fearing with fear, favor, fervor, and fiat. That is not the chairman that we have. The chairman of the IBC, appointed under Article 250 sub-article 4 of the Constitution, must be that chairman who is a first amongst equals, just like the Chief Justice of the Supreme Court. A primus inter pares who must work with his colleagues to guide the affairs of the Commission. I urge the Court, therefore, to decline an invitation by Professor Githu Muigai that the chairman of the IBC is in a special position, different from the 4 commissioners who are crying aloud to be heard by this court. And my lords, this petition number 5, as consolidated, therefore tilts on the violation of Article 138(3)(c). It tilts on that violation. And that violation alone, my lord, therefore invites this court to look at or to turn to Articles 23 of the Constitution on your role as a court to interpret the Constitution in a manner that goes beyond just protecting human rights, my lords, but to look at what would guide your interpretation, the holistic approach, the purposive approach, And let me borrow my learned friend's approach, the Antonin Scalia's approach, the late judge of the US Supreme Court, the textual and the contextual approach. And if you apply those approaches, my lord, then you will find that the chairman of the IBC, in failing to properly construe his role under 138(3)(c) and 138(4), violated the Constitution, and an unconstitutional process therefore emerged that cannot put into place, my lord, a process that violates Article 3(2). My lords, there is an invitation to you to invalidate the entire process. And that is why in answering in answering the Supreme Court judge's question that was directed at me on remedies, I wish to state that, and this is because this court also has a purpose under Section 3 of the Supreme Court Act. And given that you're an election court under 84, in an ideal situation where you are construing Section 83 of the Elections Act, which must be interpreted disjunctively, because if there's an unconstitutional act, then the election cannot stand. If quantitatively, as we shall demonstrate, there is non-compliance, again, you'll have to invalidate the election. But my lord, in an ideal situation where you'd have been called upon to apply Article 232 on public service and Article 201 on public finance, you would have ordered a recount and then secured a winner. But this would only have been possible if there were no unconstitutional infractions that undermine the process and therefore make it unconstitutional. Because this is no longer about tallying and verification. It is about the bigger process of the involvement of commissioners and a split commission. And the only remedy available, my lords, Justice Ouko, the Chief Justice and members of the court, is a nullification. This is no longer the baby of Raila Amolo Odinga V. This is no longer the baby of William Samoei Ruto, Dr. the First Respondent. This is the baby of Wanjiku. It is the baby of Kenyans. Return this baby to Kenyans to determine to whom they shall hand over the baby after 60 days. I pray that you nullify the election. And I will cede my time now to Mr. Senator of Busia County, Okia Omtata, the perennial litigant. Thank you.
Distinguished honorable members of this court, I'll begin my submissions by requesting that my PowerPoint presentation be played.
Just to respond on points of law.
My lady, there was a question that was posed by Justice Ouko.
Yes.
To which Mr. Mohammed answered.
Okay.
And I would like to make a clarification on that. On the points of law, I think Professor has covered.
Okay. So you're only answering the question by the court?
Yes, my lady. Could the time be stopped, please, so that yes, we are going to interrogate the figures that were used here to attempt to mislead this court. I'll begin by asking the officer to play the slide number 6. That slide that contains results, when I looked at it and my other co-petitioners, we found that the maths did not add up. And that for us was a smoking gun, because figures don't lie. So, and I would also ask the court to realize that the comments we made about that particular result have not been challenged. That when you add the totals for the individual parties, you don't get the total ascribed. But the total ascribed is available in the workings and the affidavits of the members of the commission. which means we are dealing with fiction. I will request that you go to slide number 5. And the Honorable Judge asked, how are these things transmitting? So when you look at the fact that at 17 hours, we had 21,481,652 voters or returns which had been made, and we factor into when we try to calculate the average number per voting station, we were told we are given 46,299 polling stations. If you divide 22,120,458 by 46,299, you arrive at an average figure of 478, which is not very far from when you take 65% of 700, which is the maximum number you can have in a polling station, you end up with 455. So when you now come and using the 478, which is the average we have had, and divide 21,481,652, you get 44,962. From paragraph 29 of Mr. Chebukati's replying affidavit, the figure he gives is that 45,994 kids reported. Now, from this, you already see that if the kids were 46,299 and 45,994 had reported, you are only left with 305 kids. These are kids which had connected, so the question of saying that these kids were looking for connection is not there. These kids were connected and they discharged their mandate. And you have been told here that there were some kids in Eldoret who are pinging the same, we are sending results from Eldoret, I don't know, from wherever, one kit being used. So at that time, you get that the 305 kids, which may not have had network, if you multiply that figure by the maximum number of votes available, you will find that the 700, if you multiply that, you'll get a figure of about 213,500 votes. That's the maximum that could be transmitted, not 2 million votes. And also, if you went by my working of 1,337 kits, then the maximum amount you could get is 638,806. So the KIMS kits that transmitted are not these ones that reported at that time. But the data, the fact that they held so much data was mined. So somebody could transmit remotely, mining the data that was already reported in these polling stations. And that's how the fraud happens. For the workings on slide number 2, where you can clearly see that if we use the 21,481,652 as the baseline and the 12,065,803 as the baseline, you find these workings coming out, and you can see that 1.6 million votes are being submitted between 17 hours and 2045, and on and on. But most important, even if we were to buy the idea that they were connecting, you have got 508,647 ballots on page 3, slide 3, which transmitted after a period of 3 hours and 45 minutes. So those particular transmissions of 508,647 are a figure that's very curious, because if you deduct the tally for Eldas from this figure, you hit almost the exact figure that Mr. Willis, Land Council Willis, has presented to this court coming from the KPMG audit that that number of voters, there was a number of ghost voters equivalent to that one. When we go to the other thing that supports our position, there was a question of what was the denominator used for voter turnout. I will invite you to look at at the petition at page 41. There is a letter, a press statement signed by Mr. Chebukati, saying that he used the National Voter Register to calculate, and if I may just read it quickly to the court. So page 41 is handwritten 41. It says, paragraph 2, at around 4 p.m., 12,069,803 registered voters out of 12,065,803 voters out of 22,120,458 had cast their vote. This equates to 56.17% of voter turnout.
How much do you need? Because we have the slide.
Just 5 minutes.
Could we give you 2 minutes to finish?
Yes, please. That you will refer to the slides. So, when I look at that, you'll find that there's no basis for claiming that the figure that claiming that the Kim's kits were used as the denominator. It's not possible, and it's not there. Also, I would like this court to take note of how the percentages are being played with. That's slide number 10. You will find that wherever the chairman is reported 12,065,803 people voted, who voted represented 56.17 of the total registered voters of 22 that. At paragraph 26 of the replying affidavit, Mr. Sunkuli, using the same number of voters, 12,065,803, but as reported by the chairman, but again as a different number, as a denominator, he arrives at the same percentage. So there you can see how they can play with numbers by changing the denominators and arriving at magical figures. So my members of the Honorable Court, my prayer is that my submissions are that these figures are cooked, they were worked backwards to achieve a certain figure, but fortunately on the Form 34C, the smoking gun is seen. And since figures don't lie, and if the math doesn't add up, then this court should quash the results. We were told about military precision. Military precision is the ability to shoot a bullet with a bullet. That's how a missile downs another missile. That is not what we are saying here. There's no military precision in these figures.
The last petitioner, 7th petitioner, Julia Nyoka Bichege, and others.
May it please you, Melody, Madam CJ, and other members of the court, to go straight to the issue. I've had a lot of Shakespeare and other learned fellas. I went to public schools. I may not be able to remember anything about Shakespeare, but Madam CJ, besides a Greek philosopher known as Plotinus and Adam Smith, my favorite philosopher is called Karl Marx. And one of the most famous quotes that he made is this: that history repeats itself. First as tragedy, second as farce. Now, I go to my issue. Yesterday, Madam CJ, when I was listening to my learned colleague, Mr. George Oraro, Senior Counsel, I could not fail seeing the echoes of 2007 in what is happening today. Madam CJ, in 2007, the secretary to the commission, just like this year, was at the heart of what happened. The secretary was called Suleiman Chege. The secretary today is called Hussein Marjani. Same problem of numbers. The Kenya law reports would bear, and Mr. Isa Mansour is also here, that I represented Samuel Kivuitu and others when they were removed from office. Now, it turns out that, and listening to my learned colleagues, that just like in 2007, the person who knew why the results are like that was Suleiman Chege. Listening to the presentation yesterday, it also appears that the only person who really can tell us about these numbers is Hussein Marjani. Second similarity is that both Raila Odinga and William Ruto were at the heart of what happened in the year 2007. But that is not the more important point. The more important point is the differences. The differences were these. In 2007, and under the constitution that was existing that time, the election was announced on the 30th of December 2007. And the president sworn on that day assumed office. But the difference this year is this: after 15th courtesy of the new constitutions, on the 15th of August when the declaration was made, the person designated as the winner by Chebukati became president-elect. That's an important distinction. The second most important distinction is this: that the former constitution of Kenya did not have an equivalent of 138 of the constitution. There is that distinction today, which is what I was calling stage 3 of a presidential election. It was never there. The next issue was that in 2007, the presidential elections were held by the High Court under its original jurisdiction and special jurisdictions of elections. This one comes to the Supreme Court, and the basis upon which that is done is on the basis of Article 140 of the Constitution. There is no sitting president who will be appearing before you. There is only a president-elect. Now, my first petitioner, Julia Chege, asked me, because there was a subjective question that was posed in her view by Judge Smoky Nwanjala, that how come there was no protestations by these people when they were being given domestic chores? According to Julia Chege, who had to resign from her university job as a lecturer, there is something that needs to be understood. That for 99% of the human population, you want to follow the natural order of things. You don't disturb things. You let them things as they are. So that to Julia Chege, it is important that the court must understand that from your point of view, a lot of you, and she knows that history, have had a previous opportunity to stand up for something, an opportunity to say no. Not everybody has had that opportunity. And therefore, the 4 commissioners for ultimately, on the 15th, having the courage to have something to stand for. They are heroines and heroes of this country. We come now talking about heroes to what my professor of criminal law and procedure, Dr. Gethu Muigai, said. Dr. Muigai, looking straight to the face of this court, said 2 things. A, the problems in our elections is not IEBC, but the candidates. History does not support that conclusion. Second thing he said, B, Wafula Chebukati is a national hero. I don't have to say anything on that. Now, Madam CJ, there is the issue of the word independent, or in the designation of IEBC. The word independent, it is further elaborated by under Section 26 of the IEBC Act. It says IEBC is independent, but shall be subject to public participation and to engage stakeholders in the discharge of its mandate. Madam CJ and members of this court, I flatter myself quite often that I have a reasonable understanding of Kenya's electoral laws. However, Madam CJ, listening to my learned colleagues yesterday, I had a lot of reasons to doubt whether that is true, if what they said is actually the true representation of the law. And in several senses, under Article 81, the election should be simple, accountable, accurate. But until yesterday, my understanding was this, that reference to the Commission and Article 81, 86, 88, and 138 of the Constitution triggers the image of Chebukati and 6 others. I've never imagined Marjani and other returning officers when we talk about the Commission. B, based on sections 10 and 11 of the IEBC Act, my understanding has always been that the Secretary of IEBC is the chief executive, the head of the secretariat, the main employee of the commissioners, who appoints him. But now it appears to be that for purposes of a presidential election, and we heard it from his lawyers, he's actually the main man. Was this what the Constitution wanted it to be? Welcome to the Republic of Kusadikika. I must agree with my learned colleague, Mr. Mudhomi Kidiankulu, that it would appear that since we did our elections, we became some kind of a terrestrial Kusadikika, and several questions arise. When, why, and how? When did this happen? It first happened just before midnight on 9th of August, when we retired to bed. One figure we ought to have had was not known. How many of us voted? That is the when. How did it happen? It happened because on the 8th of August 2022, Wafula Chebukati published that Gazette notice that I talked about. On the face of it, makes the chairman a dictator. No, that is not the issue. If you read it as an instruction manual, it was to give the job to Hussein Marjani. That is what happened. Why did it happen? It happened, and we explained in our affidavits, paragraphs 42 to 45, and what they say that effectively, on the 15th of August, when these elections were declared, from 7:30 to 6 p.m. on that day, the Commission, as the Commission, had lost effective control under Article 138 of the Constitution. I come, because I'm trying to rush myself, to the petition, number 7. This petition, Madam CJ, is actually a numbers petition. I didn't want to make a lot of fuss that I would have needed more time, but in case my mouth does not go fast enough, I urge you that you give me a little leeway to conclude what I need to say. The issue is this, Madam CJ. When you pose the question that you posed, how do you have evidence 700,000 people did not vote? You triggered some kind of public participation on my phone. I had many calls. Kibe, why did you just say it's 700? It's about 3 million. But of course I had to tell them, no, we just said 700 because we had some kind of evidence. So it's a big issue, Madam CJ, that you triggered a public participation. So many people don't vote on account of non-enforcement of Regulation 90 by IEBC. Now, for whatever the value is this, I can demonstrate very shortly, and we've done that in our petition and in our, in our affidavit, that when you have a petition based on non-compliance, how do you prove it? We have an affidavit of Julia Chege that basically has not been controverted. She says where she was voting. She was voting as an MP she was contesting the office of Kangema. And she said how she interacted with election officials. There were no affidavits sworn by the commissions to say those interactions she talked about were not true. But more importantly is this. When you say Regulation 90 says you are going to publish notices on how election officials and security officers are going to vote, IEBC needed to do a very simple thing. Namely, what did you publish to implement it? If you didn't publish anything to implement it, you are responsible for non-compliance. How do you treat non-compliance? You tell the Supreme Court. We could not be able to have non-compliance for reason A, B, C, D. Then the Supreme Court may decide to excuse you or not. But in the absence of that, non-compliance has been proven. What is the effect of this non-compliance? We have stated in our further affidavit, it's a numbers thing. If 700,000 people did not vote and you adjust it whichever way you want, you will still have a figure of 300,000. So that the long and short of it, my ladies and my lords, is this. Unless you excuse IEBC, and they did not ask you to excuse them, then you must find that the numbers in petition number 7 could have altered if those people had voted the results of the general election. And therefore, it is not permissible for anybody to be able to say, oh, it's a numbers thing. Petitioners brought no number. We brought numbers, and there was no response. We come to the issues of the issues of the procedure under Article 138. Under Article 138, that's one of the best done judgments that I've read. I've read it many times. It was written by artist Judge Jouko was there writing it. Catherine Mantoinoti was there. He was my people master. One of the best written judgments. I've read it many times. But yesterday, it somehow appeared I don't understand these things. So I read one more time yesterday night. And I thought, I think I understand what it says. So it was violated in 3 major ways, my lady. Number one is this, issues of the voter turnout. The issues of the voter turnout until yesterday, I thought is usually settled before the elections through the gazettement of a voters register. For these elections, it was done on the 21st of June 2022 through Gazette number 7290. But listening to my learned colleague, Mr. Somane, it would appear that fairly educated people like James Orengo, Firoz Noroji, Paul Mwangi can actually write petitions, and they were told in open court they did not understand what is all this about Article 190. And I also shuddered that if they didn't understand, probably I also did not. The second failure is this. In short, I'm saying the register cannot be mysterious. If the register is mysterious, the election is not simple, does not meet the requirement of Articles 81 and 86. Number two, the stoppage of the public display. I didn't hear a straight answer to that. Now that there was no straight answer to the issues of the failure of results, and the 27 were not read, that goes straight to the root of the procedure under 138. If that was not done, my lords, there is no way in which you can be able to say the election was valid. For a simple reason, which is this. That when... can I have 2 minutes? 2 minutes. Yes, I can give you 2 minutes. For the simple reason that we were dealing with under article, for the conclusion, the whole point about Article 138 is that the procedure must be concluded. If it is disrupted, you have to hold that Article 138 was violated. The next issue is this, the third one. We talked about the issue of effective control. If you are convinced by what you have heard, and we have gone through this in the last 2-3 days, that IEBC lost effective control from 7:30 on the 15th to 6 p.m. when the results were read, there can be no basis for this court to say anyone was validly elected as president of Kenya. My learned colleague, Mr. Fred Ngatia, whom I respect a lot, said that William Ruto won these elections fair and square. That expression, fair and square, to my mind, comes from, as I understood, the famous judgment where Judge Madan was in the Githunguri case, where the basic point was this, that certain issues may happen that may make even a person who on the face of it could have been liable for criminal offenses not to be properly tried. And therefore they said it makes any convictions to be bad in law. You do not have a fair and square deal. Under Article 138, Raila Odinga, the other surrogate petitioners, they need a fair and square deal that their votes were not enough. Finally, my lady, the Chief Justice, Article 138 must not die in your hands. We are most obliged.
I think that brings us to the end of... Yes, that brings us to the end of Rejoice. We are looking at Senior Counsel, Mr. Mwite, but we know very well your clients were respondents. It was only for the under representation that we allowed them to come just after the petitioners. They do not have a right of rejoinder.
Chief Justice, I am acutely aware of the time constraints within which this honorable court must adjudicate on this petition. And may I say that this honorable court is entitled, suo motu, to decide that the 14 days specified in Article 140 mean 14 working days. Yes, to exclude Saturday, Sunday, and public holidays. You can do that, suo motu. I am pleading, Chief Justice, I'm pleading on behalf of the 4 commissioners. I plead. They have had very, very little time in this court. I plead.
Well, that is why I was looking at you with the questioning eye, because there were some questions also which were asked, and they need to be responded to.
Yes, those are the ones. I'm just pleading.
Yes.
Allow my colleague Mansu Issa some 8 minutes, and Dr. Arroa some 3 minutes, and yours truly some 2 minutes only.
That is 15 minutes.
Because
to answer those questions.
No, because, Chief Justice,
yes,
those questions directed at those 4 commissioners are very important. And others were answering questions, a lot of maligning, a lot of... please give them that opportunity to have their case stated. They are the majority in that commission.
Thank you, Senior Counsel. I think we've heard your plea because we asked questions. So we'll give them 15 minutes to answer, not now. We want to take a break. And immediately we finish, there was an issue raised by Senior Counsel Gatia responding to some two Forms 34, and you asked for 5 minutes. And then we will give the parties 15 minutes, not all the parties, the ones who are connected with the discovery and the scrutiny, 15 minutes in the afternoon to respond to the report.
I request, Madam Chief Justice, may I request 5 minutes for the Commission, because we are the custodians of the form, the legitimate forms.
Yes.
And my learned friend, Mr. Orengo, needs his lunch now. He's heckling.
Okay, we'll give you 5 minutes, and the court will arise.
Well, there you have it. It is the live pictures from the Supreme Court. The judges have retired for a couple of minutes, and then they will be back for the last rejoinder. Remember, it is the third day of hearing, and the last being the rejoinder day, the hearing before the 7-judge bench. And after that, they're going to be retiring to make a determination on the Raila Odinga and Martha Karua petition, live from the Milimani Law Courts, where the Supreme Court has been domiciled for the better part of this week. Of course, a lot has been talked about in matters rejoinder, but something has just come up and just will not go. If you look at the social media platforms, there's a lot talking about names of judges and how they've been carrying out themselves and lawyers, but one name has refused to just go away, and that is Jose Camargo, after one of the Form 34A has been identified having his name. And flashing back to July the 21st, you do remember there were 4 Venezuelans who had landed in Kenya with some IEBC election materials, and Jose Camargo, if you like, Oje in Spanish, Camargo was one of those people. That is Jose Gregorio Camargo Castellano. And the name itself, just one of the issues that has made part of the submissions in this morning. And other than that, of course, the rejoinders by all the petitioners. Remember, they were all consolidated into one petition. My name is Ben Troinjue, and for now, let's look at exactly what has just transpired. I'm joined by a constitutional lawyer, Henry Kurauka, who we have been having for the better part of this week. Thank you so much, Counsel, for making time. I don't know where to begin because a lot has just transpired, but the name, Jose Gregorio Camargo Castellano, just refuses to go away after it was discovered in one of the forms. How does this pan out when it comes to the submission? It was not in the original submissions that were made, but it has just come up on the day of rejoinders. Actually, it's the one that is trending on Twitter.
Thank you so much. I think that is a very triable issue that has arisen because it touches on integrity of the information, the results, and it is an issue that the judges should determine. When a party is involved in uploading those forms, then that party must be authorized by the commission to do so. And if there is any foreigner or maybe an authorized person doing so, then that becomes a serious matter. But we hope the judges will be able to analyze the evidence and make a decision on that. Another issue that is coming out very well is the division of IBC commissioners. That is another very serious issue that has arisen and which we expect the honorable judges to make a decision on, because on one side, I remember my lecturer, Professor Gidu, saying the commissioner did a fantastic job. But on the other hand, the petitioners are saying he did it alone. He shouldn't have involved the other commissioners. So we need now the Honorable Court to render a decision, an opinion as to where the role of IBC as the commission ends and leaves the chairperson to announce the results, because it's a process. You know, there is the issue of counting, tallying, verification. That is squarely the role of IBC pursuant to Article 138, subsection 3C. But when you read Article 138, subsection 10, it is the chairperson to announce the results.
And another pertinent question that has come up regarding why the chairman of the commission, Wafula Chebukati, indeed they've talked about there was some violence and some chaos, to the point that they even presented a video in court to support that. And the question was, actually it was raised by one of the judges, that the commission chairman had a day to put his house in order, perhaps try to reconcile with the 4 commissioners so that they may come up with one cohesive report, and that is to announce the presidential result. And also something that has also come up is that they are questioning or quizzing why Kenyans were glued to their screen. But unfortunately, there's a time that came that the results the portal they stopped displaying those results. There are some issues that are going to come up.
Yes, I think the issue of violence, though it has featured, I don't think it's a very serious issue related to the petitions. The reason being that on one side, we have some lawyers saying, yes, there was a quiet entertaining Kenyans until very late. And that could not have happened if there was continuous chaos. Others may argue that, yes, there was some chaos, but they did not last for long, or they did not substantially affect the work of the chairman. It's unfortunate that there's some, IBC officials were injured. My view is that the judges will have to look at the law as it is, and the procedure of elections was the tallying, verification and counting done within the law. If the answer is yes, then they will ask, was the elections free, fair and transparent as per the Constitution and the Election Act? If the answer is in the affirmative, they will proceed to validate. Remember, the jurisdiction of the Supreme Court is derived from our Constitution, which gives the court the singular mandate to determine election results relating to the presidential elections. And as one lawyer rightly put it, like for example in DRC Congo, the Supreme Court proceeds to even validate the results even without a petition filed. So you can see how many countries have placed the court in that respect. Of course, there are many other aspects relating to the election that the Honorable Court lacks jurisdiction. For example, the orders that Moses Kuria was requesting were completely out of the jurisdiction of the court. The issues like violence, unless they touch on the integrity and they affect the final results or the election, those become issues. Some issues that have arisen and have been raised by various parties are not issues for this honorable court. They can be raised to the police, investigations can be done, action can be taken, other issues should emanate from the other courts. For example, if IBC commissioners have any issues relating to their performance, I think some of those issues relating to how they manage their day-to-day activities should be referred to the Employment and Labor Relations Court first for determination. And that's why the Supreme Court rightly refused to be involved in determining their legal team.
Yes, and my director informs me we need to go to the news, but before we do that, Article 138.10 on a declaration by the chairman of the commission, but looking at even 2013, 2017, the issue of the server has always crept up in terms of the elections petitions, and one of the issue is, of course, the DCI also talked about when it comes to servers, a lot of people had administrator rights, of which has raised a lot of questions, including Jose Camago's name has also appeared again. This is something that we have done in 2013, talking about servers, 2017, talking about server. Now we are also in the same place, talking about server and also a new one, portal.
Yes, in its judgment, we expect the Supreme Court to make guidelines to render an opinion or opinions in respect of all those matters. Yes, it is true. The chairperson is supposed to announce the results, but the chairperson cannot announce incorrect results. These results must meet the other standards set out in 138 subsection 3C, whereby the commission is supposed to do all those other processes of counting, tallying, and verifications, and so on. So the final results should be accurate.
Thank you. And let's now cross over to the other side. We are keeping a keen eye. Remember, the judges have just retired for a break, maybe a health break, but they will be coming back. Remember, it's the last day before the judges do retire to make a determination that we do expect on Monday, very early in the morning, and we expect to see how that pans out. Let's first of all have a quick break as we still monitor what is happening at the Supreme Court. We'll be back with the news. I can see Nisi Mano is on standby, but let's take a quick break. We'll be right back.